All right, I will start by calling the roll. Senator Edwards, Senator Surville,
Here.
Delegate Bagby, Delegate Price,
Here.
Delegate Mullen, Delegate Samira.
Here.
Thank you. Christy Kelly,
Here.
James Zabrinio,
Here.
Stacy Pendleton, and for Allison Land.
Here.
Thank you. Norman Oliver and Duke Storin. All right, we do have a quorum of voting members. The first item on the agenda will be to elect a chairman, and I will open the floor for nominations of chair.
I move Senator Edwards as chairman.
All right, Senator Edwards, is there a second?
Second, this is Delegate Price.
Thank you.
I move that we close nominations.
All right, nominations
Second.
are now. And now we will vote on the nomination of Senator Edwards as chair. All those in favor, please say aye.
Aye.
Any opposed? That'll be unanimous. Then up next will be the election of vice chair. I'll open the floor for any nominations of vice chair.
Marcia, you want?
Yeah, I was going to say, can you nominate yourself, or is that unheard
Okay. I move Delegate Price.
of? Second.
All right, there's a Delegate Price has been nominated second, and we'll close the nominations. All those in favor of Delegate Price, please vote aye.
Aye.
Any opposed? It is unanimous. Delegate Price, as vice chair, I will hand this meeting over to you.
Yes, and if IT could let me in, I'm trying to get in from my computer, and then I can be on camera. But we'll go on and start with the first order of business, and go on and kick it over to the staff presentations.
Sure. So I'm Anna Moyer. I'm an attorney with the Division of Legislative Services, and I'm just going to do a little overview of Senate Joint Resolution 35 and the subcommittee, just some housekeeping stuff. So Senate Joint Resolution 35 establishes the Joint Subcommittee to study barrier crimes and criminal history records checks to study the Commonwealth's laws related to barrier crimes and criminal history records checks and develop recommendations related to 1, whether statutory provisions related to criminal history records checks, barrier crimes, and barrier crime exceptions should be reorganized and consolidated into a central location in the Code of Virginia. 2, whether certain crimes should be removed from the list of barrier crimes. 3, whether barrier crime exceptions and waiver processes should be broadened. 4, whether the required amount of time that must lapse after conviction of certain barrier crimes should be shortened. And 5, other changes that could be made to criminal history records check and barrier crimes requirements that would improve the organization, effectiveness, and fairness of such provisions. Senate Joint Resolution 35 establishes the Joint Subcommittee as a 1-year study and directs the Joint Subcommittee to complete its work by November 30th of this year. The Joint Subcommittee is limited to no more than 4 meetings during the 2020 interim. The chairman of the Joint Subcommittee must submit an executive summary of the Joint Subcommittee's findings and recommendations no later than the first day of the 2021 regular session. To facilitate effective and efficient work during the remaining weeks of the 2020 interim, the Joint Subcommittee might wish to schedule all remaining meetings as soon as possible. Future meetings might include comments from stakeholders and other interested parties. At the end of this meeting, you all will have time to discuss issues and items for inclusion in the work plan and goals of the study. Following this meeting, Sabrina and I will prepare a work plan to help guide the work of the Joint Subcommittee in the time that remains. One option to consider as you listen to the background and history of this topic and discuss issues and items for the work plan is the potential to extend the study for an additional year, so as to allow sufficient time to address this complex and important topic in a meaningful way. If you choose to do so, it will be necessary for you all to request and introduce a joint resolution continuing the study for an additional year. And then Sabrina and I can prepare a draft of that continuing resolution for you all to consider and vote on at your next meeting. So Madam Chair, that concludes my overview of Senate Joint Resolution 35. I'm happy to answer any questions, or I can go ahead and move into a brief background and history of this topic.
Are there any questions from any of the members and staff?
Hearing none, please continue.
Okay. So to give a brief background, as many of you probably know, issues around barrier crimes have been discussed and introduced through legislation for many years now. Senator Edwards has introduced multiple pieces of legislation, including Senate Bill 1243 in 2011, which included the explanation of crimes, but that was left in courts of justice. And a similar bill, Senate Bill 97 in 2012, which was carried over to 2013, but died for a lack of action. He also introduced Senate Bill 868 in 2013, which sought to clarify the list of barrier crimes for individuals seeking employment or seeking to provide contract services in various industries, but that was passed by indefinitely. And that same year, he introduced a study to address similar issues outlined in this study, but that was stricken at the time. In 2014, Senator Edwards introduced Senate Bill 353 that set out the list of barrier crimes for various professions and groups, and that will be discussed in more detail in this presentation. In 2017, Senator Hanger introduced Senate Bill 1008, which passed, and that bill sought to clarify the individual crimes that constitute a barrier for various professions and groups. Senator Hanger's bill also moved the comprehensive list of barrier crimes to section 19.2-392.02. So ultimately, previous legislation addressed the first issue in Senate Joint Resolution 35, but did not necessarily address all of the other questions posed to this joint subcommittee. So that's just a brief overview of past legislation and where we are now. And my co-attorney Sabrina is now going to talk about Senator Edwards' Bill 353 from 2014 and Senator Hanger's Senate Bill 1008 from 2017. Sabrina?
Yep. Thank you, Anna and Madam Chair. As Anna said, I'm going to give you a brief overview of Senator Edwards' 2014 bill, Senate Bill 353, and then Senator Hanger's bill from 2017, Senate Bill 1008. Senate Bill 353 was introduced during the 2014 session and was ultimately left in courts of justice. The bill enumerates specific barrier crimes for individuals seeking employment in certain agencies or facilities, including nursing homes, community service boards, behavioral health authorities, adult daycare centers, children's welfare agencies, and children's residential facilities. These crimes also bar applicants from licensure of certain facilities, as well as prohibit individuals from fostering, adopting if they have been convicted of any of the crimes. Of the code sections that list the crimes that constitute a bar, all but those in Titles 32.1 and 37.2 specify that an individual is barred if they've been convicted of or adjudicated delinquent based on the listed crimes. We've provided a handout with the full list of crimes. There's about 120 barrier crimes, so I'm not going to list those individually for the sake of time. The handout, and so for the most part, each amended code section in SB 353 includes either this full list of about 120 different crimes, but some sections do leave out select few drug-related and other various offenses. Additionally, 9 of the amended code sections provide that any felony offense other than those listed will be a barrier if less than 5 years have elapsed between the date of conviction and the application. SB 1008 was introduced, as Anna said, by Senator Hanger during the 2017 session and became effective on July 1st, 2017. SB 1008 amends section 19.2-392.02 to become a definition of barrier crime, which essentially contains the comprehensive list of crimes that bar employment, volunteer services, etc. The bill deletes the individual lists of crimes and amends them to refer instead to the comprehensive list in 19.2-392.02. The bill also specifies that the bar applies to anyone who has been convicted of, so it removes the adjudicated delinquent language, and then this language can be found in those portions of each amended code section where 19.2-392.02 is referenced. And then while SB 1008 removes 5 crimes, including one that was repealed, it adds about 30 new barrier crimes to the overall master list of crimes. The additions and removals are also listed on the document I provided. I'm happy to go over those in more depth if anybody would like me to do so. Generally, the additional crimes involve acts of terrorism, certain additional sex offenses, and crimes listed under Article 5, Chapter 9 of 18.2. And as passed, Section 19.2.392.02 has a similar kind of catch-all provision that includes any of the other felonies not included in the list unless 5 years have elapsed from the date of conviction. In addition to this longer list of barrier crimes, some sections specify that an individual who's on probation or parole or who has failed to pay court costs will also be barred from compensated employment, specifically in the Department of Behavioral Health and Developmental Services. Also, for those amended sections under Title 63.2, a founded complaint of child abuse or neglect will also be a bar on employment. As I mentioned, this is a fairly high-level overview. The specific crimes are included in the PDF provided if you'd like to use that for reference. And I'm open to any questions, but that's all I've got.
Madam Chair.
Yeah, I'm sorry. I saw Delegate Mullen's hand first, and then we'll come to you, Senator.
So, Madam Chair, for me, going through these code sections was very complex, and we have a lot of areas of the criminal code right now that I think are probably unnecessarily complex. And so one of the things that I would suggest that as we go through this process of examining barrier crimes is that we try to simplify the language and try to be able to bring everything together in one specific code section instead of scattering it throughout the code. I think that would just be helpful for practitioners, for judges, and then for everyone who works at places like the CSB. The other thing that I wanted to sort of bring out as sort of something that I found important was that I was unaware that barrier crimes also affected an ability to be able to adopt, which was something that was really upsetting to me. And so as we are discussing the role that barrier crime should have in the code, I would like us to think about eliminating adoption as a whole from specific statutory bars. Judges will always have the opportunity to take those into account in the fact that there is an adoption ongoing. But I thought that there was a blanket statutory bar was pretty anathema.
Thank you, Delegate Mullen. Senator Servo?
Thank you, Madam Chairman. I have a question, I think, for Anna, Ms. Moore. Hey, in your review of the bills that you went through, you didn't mention the bill I introduced in 2016, which is Senate Bill 318, which was a certificate of relief from the collateral consequences of a barrier crime. Have you all had a chance to review that?
We have not. I was just trying to cover, so there's been a lot of bills on barrier crimes over the years. I was just kind of trying to cover Senator Edwards, but I can definitely add that as part of the work plan if you would like me to.
Yes.
Senator Servo, is that from the email?
It's an email I sent to the members, yes,
Okay.
but I didn't send it to staff, though.
Okay.
Yeah, Madam, go ahead.
Delegate Mullen?
Could you just share that with staff as well? Because I found that email and the attachments that you sent to be very helpful in sort of understanding what was going on here. So if you could share that with staff, I'd appreciate it.
Okay. You okay with that, Senator Servo?
Sure. Okay.
And then we can get that. Now, do we need to take formal votes on what to add to the work plan, or are we just having conversations? Because I only see 3 of us right now.
Just conversations today, and then I'll kind of pull it together, and we can continue to work on it in other meetings too. But I'm just going to try to get an idea of what you all are thinking now, and then I'll put it together.
And Madam Chair, I had some other stuff too.
Oh, okay. Go for it, Senator.
Thank you. So one of the things that I think that we ought to look at is, I know Senator Edwards has been very focused on, and Delegate Mullen just commented on sort of how the code ought to be structured. The email that I sent around to everybody that you all haven't seen copied or provided a link to the approach they've taken in North Carolina, which is there's an organization which has consolidated all their barrier crime information, or their collateral consequences actually is what they use, the term they use, into a database, so that an individual can go online and say, if I'm convicted of this offense, here are all the collateral consequences that flow from it. And you just put a code section in, and then it spits out all this information so you can see it. And it would strike me that that approach might provide people, not only people subject to the conviction, but people trying to hire somebody or whatever, with a much more comprehensive view of all the various collateral consequences that flow from a conviction, as opposed to simply the barrier to employment piece. I mean, for example, if you're convicted of a DUI, it has consequences on a CDL, but I'm not sure that's a barrier, but it's certainly a collateral consequence, and it's kind of very related, but it's not the same. But anyways, that's the approach I think some other states have done, and I think that might be an alternative, is to establish sort of perhaps a state database of collateral consequences of convictions that could be used, as opposed to putting something in the code where you can go look at a code section. So I just like to see what other states have done in terms of consolidating information and providing that information. That's another thing I had. And Madam Chairman, I had one other thing.
Go for it.
Thank you. And Christy Kelly is on the call here. I mean, she's one of our members too, and she's much more of an expert on this stuff than I am. But a lot of this barrier crime stuff plays into employment background check issues, and obviously that's part of the study. I noticed is, I think it was section 5 of the study. It says something about background checks or something. Oh, I got rid of the language. Anyways, my point is that a lot of background check law is governed by federal law, and I think it's critical that whatever we do, that it squares up with basically enhancing or improving or making it possible for Virginians to have the ability to ensure that accurate information is being put out about them by background check companies and or the people that provide this information. And I think that's part of what we do. We need to make sure that we're using the right statutory language so that Virginians have sort of a full set of remedies available to them when inaccurate information is put out. And Christy could probably speak to that better than I can, but anyways, I just think that needs to be part of the discussion.
Okay. Delegate Muller.
Thank you, Madam Chair. Madam Chair, I wanted to sort of amplify what Senator Serval just said, because I think it's very helpful. First, if we have a central database like what is being discussed, I think that would also allow for the Office of the Executive Secretary to develop forms that can be provided about collateral consequences at the time of conviction. We already have, as part of a colloquy, judges who are telling people about the immigration consequences, and that's a result of a specific Supreme Court case. But we can go further as a Commonwealth to let people know when they're in court what could happen to them as a result of their conviction. The idea that somebody is a year or 2 years away, out, surprised by the fact that they can't adopt a child or work for a CSB because they were convicted of a crime and no one told them is, I think, a real problem. So I think the North Carolina approach that Senator Serval had suggested is a good one. I am thinking about this barrier crimes discussion in tandem with the discussion that the Crime Commission is currently having about expungement, because I don't think you can do one without the other. And I think Senator Serval is in agreement with me about that, is we kind of have to walk and chew gum at the same time. And so if this is not reflective of some of the same sort of conversations that are happening in the Crime Commission, then we're missing out a piece of this. And so I would just want us to make sure that our processes and our timelines fit those that are coming from the Crime Commission. It gave preliminary findings about 4 weeks ago, but a final complete study is coming by January 1st or so. And so I would just hope that we can combine these discussions, even if it's not explicitly, certainly in the backs of our head.
And so I definitely hear that. That was one of the questions that can't remember which one, but one of our lovely staff members was saying that we need to decide about the timeline if we were adding time to it. So I think I would want to see, of the things that we're mentioning, are there any longer term things that could this be like a phased work plan, since January literally is around the corner? We want to make sure that we're giving staff a chance to look at things. Staff, do you want to have some input on if it could be phased there, if there's some immediate things that align with the expungement conversation and then some things that we could do a little later, or does it all need to have to be done by the date that we choose today?
So we can definitely extend things. I definitely think it might be a good idea. The first thing we would have to do, since this resolution is supposed to be done by November 30th, is we can do a continuing resolution that I can prepare for the next meeting. And so that would make it so the study would extend for another year, which I think is a good idea, given all the reasons that you all just mentioned. And then, yeah, that's pretty much how it would work. As you were saying, I would probably come up with a phased work plan. And I mean, I think it's good too with work plans for one thing to kind of build on the other, like is, certain group, looks at this and then that helps another group look at that as it would go on. I haven't written it all down yet, so I'm not exactly sure how it'll look, but the first step would be extending the study and then we can pull together a solid work plan.
And so I think with the nodding of the heads, I'm seeing that we are conversationally interested in doing that at a time where we have a quorum. So that's something that you said you can prepare. And then at our next meeting, we can actually vote on that.
Madam Chair, yes. Yes.
Okay, awesome. Did Senator Servo or Delegate Mullen have anything else? If not, we can definitely hear from Ms. Kelly if you had anything to add to the conversation.
Sure. Thank you for inviting me on this commission. I really appreciate it. I think it's a great thing to be looking into. And so I just wanted to thank everyone for inviting me here. But I, with what Scott was saying, I think that it is really important to understand what we're trying to do as part of the federal framework. There have been a lot of states that have taken really aggressive actions to make reforms only to have their laws struck down because of issues of preemption or other things. And I don't think that Virginia wants to make that same mistake. I also think that I echo what everyone has said, that this really has to be in conjunction with what the Crime Commission is doing on expungements. I'm really involved with the Legal Aid Justice Center and other legal aid organizations, and understand what has been proposed in special sessions and some of the issues and why it is being carried over to January because of some of the concerns. And I think they're all valid. And I don't think that I think the language is so important that the language is correct and specific, whether it's things are sealed or expunged, or there's a procedure, permission to, undertake certain employment, and that record is not sealed or expunged. I mean, it really matters when you're doing an employment background check and you're trying to get jobs, the language that is used and the effect of that language. So if something is expunged, you can't just say this is expunged. You have to go further and say, and that means that this never happened. And so if that is a question on an application, you can literally check that you have not been convicted, because otherwise, if our law is not clear and it's not cohesive, it just creates confusion, because an employer will then disqualify someone from employment if a background report shows up something where they said, I've never been convicted of a crime, because they understood it to be expunged, and it comes up on some background check, they will lose their job, right? For fraud, not for having any other problem, but an honest mistake. And so I just think it's really important to get the language right. And I don't think you can do it effectively piecemeal. And so I echo the sentiments of everyone that this has to be in conjunction with the Crime Commission. I think it's really, really important.
Awesome. Thank you. Thank you. Delegate Mullen, I think I saw your hand.
Yes, Madam Chair. I think this is a question for Christy, but it could also be for staff. I'm not sure. I could also just be speaking into the ether. But one of the things that Senator Serval has raised, and some at least one prominent attorney down here on the peninsula has raised, is the issue of private background check companies that are currently scraping our databases on a regular basis, and that's the primary way in which new employers are finding out about prior convictions or conduct. And I'm not aware of the ways in which other states have currently handled that issue. I can't imagine we're the first to have to deal with that. And so I'm wondering how you deal with the private background check problem in other places.
Yeah, and if you don't, I'm happy to answer that question if you don't mind. Just taking a step back, just so everyone's on the same page. Under the Fair Credit Reporting Act, it's a federal statute that governs the sale of consumer reports and consumer information by credit bureaus or other consumer reporting agencies that assemble and maintain data. And it provides that information has to be accurate and up to date. And so what you're talking about is not really a problem for an entity that considers itself a consumer reporting agency and governed by the FCRA. The problem is that the entities that are gathering and selling this information do not consider themselves consumer reporting agencies or governed by the Fair Credit Reporting Act. So they just think they are vendors, data brokers, and no law covers them. So they don't think they need to have accurate information. They don't think they need to have complete information. It does not need to be up to date. They don't have matching criteria that would comply with the Fair Credit Reporting Act. And so that is where the problem occurs, because from those entities are where the consumer reporting agencies get their data. And those entities will sell data sometimes to employers directly, sometimes through third, fourth, fifth parties. And so that is the problem. And I know, I'd worked with Scott and Len Bennett on trying to get this data broker bill where they would be covered, and you don't really have the issue of preemption because those entities are not covered under the Fair Credit Reporting Act by how they try to structure themselves. And so you don't really have those issues of preemption, and you can impose the same requirements on them to have accuracy, to have damages for reporting expunged or out of date or inaccurate information. And that's really the problem, is that there are no remedies or governance of these entities right now. California just passed this very bold, data broker bill, and every business in the nation hates it, right? And I don't know that Virginia wants to go that far, but there are some bills, I think, in Vermont and some other states that have sought to regulate some of these entities, require registration, require, certain, accuracy or standards for consumers to dispute and have certain information removed from these databases. And there are civil penalties for disseminating inaccurate information, which really is important because that's the only way that some businesses comply with the law, is by there being some sort of enforcement mechanism. And I just think that's critically important. Yes.
I'm sorry.
Yeah, Delegate Muller.
Christy, are there any states right now that require that the provision of this information be relatively contemporaneous with the request? So you're not providing information that's 2 years old? Well,
the Fair Credit Reporting Act requires, under 1681K, there's a provision that any report for an employment purpose, you either have to provide simultaneous notice to the consumer that you're furnishing a public record information about them to a potential employer, or you have to have procedures in place to ensure that your information is complete and up to date. And so, the idea behind it is that you have procedures that ensure that it's up to date, or you let a consumer know, hey, like, we're sending this information about you, like, if this isn't accurate, you need to like reach out and let them know. And so the FCRA does cover that. But the problem is that these consumer reporting agencies get this crappy data from like these brokers, and these brokers aren't governed. And so you can't, I'm sorry. Sorry, my son just woke up from a nap. So you can't really preempt that part of it, but I think the way to go is to regulate it, to cut off this flow of information, inaccurate information from a data broker, so that it doesn't to the consumer reporting agency.
And Madam Chair.
Hold on. Do you need a minute?
No, my husband is actually here.
Okay.
He's trying
to Delegate Mullen,
my youngest.
Sorry. That was the most adorable thing that I've seen all day. So that's awesome. I guess, so I agree with you that we can't deal with things that would already be covered under the Fair Credit Reporting Act, but we're dealing with actors that already see themselves as being outside of that arena. And so if we're talking about them, are there states that have put, in your mind, constitutionally acceptable and morally better restrictions and regulations to allow for only the dissemination of accurate information?
Well, I do want to just go back. California and I think Vermont do have a credit reporting statute that provides for injunctive relief, which isn't available under the Fair Credit Reporting Act. And that is not preempted. And that would be a huge help in this situation. Hold on one second. I'm actually going to have to bounce. Just give me 1 minute. I'm sorry.
That's fine. But
Madam Chair.
Okay. Senator Servo.
Thanks, Madam Chair. Over in the chat bar, I popped up a link to legislation I put in last session to regulate data brokers. And that bill, I believe, is at JCOTS, which of course hasn't met because we were in special session, but it got referred over to JCOTS for them to look at it, although we might be better situated to deal with it than they are. I don't know. But in any event, my bill was inspired partly off the California law she mentioned, and then partly off the Vermont law. But that was an approach I took, and it woke up about 18 lobbyists who appeared in my office the day before the hearing, which caused me to be in this posture. So,
yeah, Senator Servo, if you can hold that thought. We've been joined by Senator Edwards. Senator Edwards, would you like for us to run down just a few of the items that we've discussed so that you can then take over seamlessly?
Yeah, that'd be great.
Okay, so and members, please chime in. But from what I'm hearing, we want to make sure that we're simplifying the language, that there is a central location within the code for barrier crimes, looking into the impact of barrier crimes on adoption and the role of judges' discretion, that we're looking into data brokering for those that find themselves in a loophole outside of the FCRA, looking at a database of collateral consequences like North Carolina, Servo had talked about, including potential forms from the OES that they can develop. We also want to make sure that we're in compliance and aligned with federal law, and that the timeline of our conversation, at least for some parts of this, would align with the Crime Commission's work on expungement, and that the next meeting we will have a continuing resolution ready for us to vote on to extend the date for which we have to complete our work. Did I miss anything?
One thing that I've thought of is some administrative appeal for people to get relief. If they got a job, but they can't take the job, that would be some simple, rather than going to court, but some simple way of going through DSS or Department of Health or whatever the agency is to say, hey, look, it's been 20 years or 5 years or whatever it is. here's why I should get some kind of relief from what is basically right now a lifetime barrier crime. The case I had, I've used this argument before. A number of years ago, the guy in Roanoke was 53, and his company handled the custodial work basically for a child care center. And they wanted him to go on the board. They wanted him chairman. And he couldn't do it because when it was about 30 years before, he and his brother got in a fight. They both were convicted of assault and battery when they were 23, 24 years old. And it barred him for life from even being involved with the daycare center. And everybody wanted him to be on the board. He wanted him chairman of the board. He was a very active member of the community, but one assault and battery years ago prevented him from doing that. And it seems, and we frequently have seen bills over the years to provide special relief for some people. So I think we need to have some kind of administrative, simple, easy to appeals process. And so somebody could apply, and then the employer could then look into it also and say, yeah, we want this guy to work, in our agency under the circumstances. So I think some kind of administrative appeal, I think, is important.
Yeah, and then Senator Edwards, right before you got there, we were joined also by Delegate Bagby, and Ms. Kelly is back, and we would love for her to finish her thoughts with her friend and introduce him. So cute. But anyway, and then Senator Edwards, I'm going to turn this back over to you.
Okay.
And so I apologize for that. My youngest just woke up from his nap. So this will be his first committee hearing. This is Tommy. But I'm sorry, Delegate Mullen, to answer your question, I was talking about how, I think the California statute that provides for injunctive relief is amazing. And I know that there's a comparable statute in Vermont. And then there are states who have started licensing different data brokers. And as I was saying, the data brokers are the ones that collect the criminal record information, and to cut off their dissemination, I think, is critically important. And there would be no issue of preemption under the FCRA. If it was injunctive relief. So.
Okay.
Mr. Chair or Madam Chair, I'm not sure who's got the.
Yeah, Delegate Mullen.
Mr. Chair, I sort of had a question with you for you, because I actually really like the idea of having some sort of non-judicial appeal process. I'm just wondering whether, because barrier crimes fall under so many different potential agencies, that if we were to do what you're suggesting, that we find one entity to which there could be an appeals process. And I don't know who you pick, but that you wouldn't have to ferret through the code just to find out who you would appeal to if you're dealing with extrajudicial remedies.
Well, as I understand it, Sarah Stanton, with my bill 2014 or whatever it was, listed the different categories. There's daycare centers in the one category, adult homes in another category, nursing homes in another category, and so forth and so on. So you had them already under my previous bill, well divided into different categories. And I think, for example, DSS oversees certain categories, Department of Health oversees other categories. So in that category, you'd already know what to do. Like if it's a nursing home, you know who to appeal to. And, each category would have, it makes sense. They have, for example, Department of Health deal with their category and DSS to deal with their category. And it'd be a simple process, and it'd be informal, because otherwise it becomes too expensive for a lot of people to do these things. That's the trouble with doing a judicial process. You got to file suit pay a filing fee, and all the rest. So that would be a simple way to do it.
I agree.
Okay, who else? Where are we? I don't have the agenda.
Mr. Chairman.
Yeah, Delegate Scott Searle.
Not for 5 years.
Senator Scott Searle.
Yeah.
Sorry.
Yeah.
How could I forget?
Yeah. Mr. Chairman, so one of the things that I commented on before you got on was the fact that I'm not sure where sort of barrier crimes and collateral consequences sort of begin and end in the spectrum of things that flow from a conviction of a crime. And I mean, I think, for example, there might be some things you might call a barrier that somebody else might call a collateral consequence, and vice versa. So, I mean, for example, how do you classify the inability to pull an ABC permit or be an ABC manager, right? Is that a collateral consequence, or is that a barrier crime? Inability, like I talked earlier about a CDL, where does that fall? There are mortgage brokers, realtors. There's all kinds of different things that could, I think, fall into one or the other. And from my perspective, in order for us to have a clear understanding of exactly what it is we're trying to get our arms around, it's important to have good information to start. And so it seems to me that one of the things I talked about was the possibility of a state having some sort of database where you could plug in a code section and be officially told, these are all the things you can't do anymore, or here's all the things you have to do differently. And it would also strike me that place would be somewhere where you could also get information about how to get out from under that. But I also think it would inform our discussion. And I'm not sure that looking at this strictly as at those statutory things about jobs is necessarily that narrow look is necessarily broad enough. And so in terms of prioritizing our work and everything, part of it seems to me is we need to understand what's the universe of consequences that flow from convictions. We need some kind of a list, or I mean, not just the list you're talking about. I think there's a bigger list that we need in order to inform our work.
Well, for example, I don't want to make this any more confusing than it already is. I don't want to mix it up with, expungements, which is a little different situation. Because, for example, lawyers are regulated by the Virginia State Bar. Realtors are regulated by the Real Estate Board. People who sell beer regulated by the ABC Board. And nursing homes, I guess, by the Department of Health. I'm not sure how that works, but I'm looking at it from the standpoint of not every barrier crime or every collateral consequence, but rather the combined collateral consequences, because that's where the barriers come from. The collateral consequence of not being able to practice law, the collateral consequence of not being able to work in a nursing home. And I would think you look at whatever the regulatory agency is, that's where you look at. There may be other consequences of, like, for example, a lawyer or anybody convicted of petty larceny, they're going to have trouble with the Federal Reserve Board as well as some employer. And so I'm trying to keep it simple to the state law as to what agency regulates what and which category. So again, the example was the nursing home. Is this a barrier crime? One. Number two, is there the Department of Health, I guess, some easy way to access that? But if you want to look at, all collateral consequences, I don't know how we're going to do that. I mean, I don't know what all the collateral consequences are. You can't work for the FBI if you've got problems with petty larceny or grand larceny or something like that. I'm trying to keep it simple.
Mr. Chairman, Mr. Chairman.
Yeah.
So thanks. So I think you walked in in the middle of or at the end of a discussion we had, but I believe sort of where the discussion had gone before you came in was that I think it was Delegate Mullen and maybe Miss Kelly who both commented that it's kind of hard to see how you can actually fully deal with the barrier crime or collateral consequence problem, whatever you want to call it, without dealing with the expungement overlap. And I would also just note that at least it's my impression that the Crime Commission intends to discuss either the expungement or sealing of convictions at some point in the next 2 months. And if we cross that Rubicon, the fact that a conviction is sealed or expunged, whichever word you use, doesn't mean it didn't happen and doesn't necessarily remove the barrier that it creates, which is why it overlaps with barrier crimes. And so there might be, like, for example, in some states, you file a petition to both seal a conviction and remove the barriers at the same time so that a judge can consider both of those things. And in some states, a judge issues you a certificate indicating that you're allowed to do those jobs, and that certificate provides the employer with immunity from any kind of negligent hiring claim, and employers really like that. And so, you know, these discussions to some extent are interwoven, and it's really hard to have them separately. And I know we'd like to keep it simple, but I'm not sure the reality is simple.
Well, we've had this discussion, you and I, and I think barrier crimes are very different than expungements. I mean, just because, you know, the case I had, the guy was convicted of assault and battery. He's always going to be convicted of assault and battery. But the question is, did that stop him from getting a job with the child care center? That's the only question. The only thing that matters. Doesn't matter whether it's still whether it's expunged or not. I mean, you can deal with the barrier, you can still get the job, but he's still going to have a record, and that's not going to be changed. Now, expungement's a different situation. I see them totally different.
Mr. Chair?
Delegate Mullen.
Thank you, Mr. Chair. I think to maybe rephrase what Senator Servo was saying, and he can correct me if I'm misinterpreting, is that we can at least, even if we can't deal with all the natural and real-world collateral consequences, that we could at least deal with the statutory ones. And so the ones that we impose by statute anywhere in the code are actionable on our end. You know, the reality that a specific type of employer might not want you if you've been convicted of misdemeanor expungement, that's not something I'm sure that we can handle legislatively. But at least with the statutory collateral consequences, we can have an effect on that. And maybe Senator Servo can correct me on that one.
Yeah, I kind of agree. Senator Servo? Anybody else? Okay, where are we now? I'm sorry, I'm late arriving at the party. What's the next issue here?
We were in the discussion piece of the agenda.
Okay, all right. So where are we? Delegate Price?
Yeah, so I did have a question for staff. What would you say, what more do you need of us in order for us to move forward with what it is you need to help us administratively?
Yes, so Senator Edwards, sorry, that was a lot. I think we're actually really good. We have a ton of stuff now for us to kind of be able to go ahead and get a work plan drafted for you all. I know that polling was sent out for you all for a time to meet in November. I don't think we have the results of that yet. So we'll plan that at that time, consolidate all of these ideas as best I can into a work plan and try to come up with something. I'll also have the continuing resolution ready to go. And if you all think of other things in the meantime that you want included or anything, you can feel free to call us anytime. Oh, and I think Charles wants to say something.
Hey, Charles?
Mr. Chair, I just wanted to point out, because I know there was some discussion about trying to see what the Commission does. The Crime Commission's last meeting will be that first week in December. which is going to be also after the pre-filing deadline. So anything this wants to do in conjunction with the Crime Commission won't be able to be done this year because the resolution provides that the meetings need to be finished by November 30th. And if the Crime Commission does something, which I'm expecting them to do that first week in December, it seems like it would be too late for this joint subcommittee.
Mr. Chair?
Yeah, Delegate Mullen.
So I think this is exactly the same thing that Delegate Price raised earlier. Thank you, Charles, for bringing that up. Perhaps what we're going to have to find ourselves doing is having a resolution for an extension, but also do preliminary work on this. As much as we can get done before the original extension, the better. But acknowledging the fact that we can't get it all done by pre-file is the reality of it.
Okay. Well, we just have to take it one step at a time. You can still file after the pre-filing. I think we'll have some kind of some limitation on that. But
Yeah,
I think these are standards. If you can file anything before pre-filing, and after pre-filing, you're limited to a certain number.
Yes, Mr. Chairman. And I would also point out that this is a short session, so I know the House members have even more restrictions on their filing ability. I'm just making this joint subcommittee aware of the time frames going forward for everything.
Well, we've had 2 long sessions already, so now we're entitled to a short session.
Hopefully.
Okay. Okay, what else we got to do? Delegate Price?
Yes, sorry, I was just mentioning that there might be the administrative workaround for the limit for some of the governor's bills as well, for anything that the administration might agree to. So I think that we should look at all of the tools that we have available for us to work around so that we don't rush the good work that I know that the staff will be helping us with.
Okay. All right. Anything else? Again, sorry I'm late. Got to earn a living somehow. Anything else? So the next meeting is when?
Senator Edwards, we are currently polling. I will get you results hopefully later on this week.
Great. Okay.
We're still waiting for your responses.
Great. Thanks so much. Okay. Appreciate everybody being here. Hope you enjoyed your drive. So the meeting's adjourned. Thank you.
Thanks, Senator.
Thank you.